Welcome everybody to the second panel of our conference, which will focus on the legal policy surrounding climate change, with an initial focus on the suits that are being brought in states and localities about climate change. I really enjoyed the last panel, but because it seems like the panelists in this conference like to argue a lot, we decided to subject you now to a panel of lawyers, where you're going to see some true professional disputation occur now, with all the rhetorical flourishes, which only started to emerge in the first panel. Now we're going to have people who just disagree for a living. So I'm really glad we could put together a balanced panel with different views, just like the first panel on these issues. And I hope we'll have plenty of time for questions and answers, because I think these lawsuits open up the issue about how should we, under our system of governance, approach questions of climate change, regardless of how you came out after listening to the first panel. Which branch of government, which level of government is the appropriate place to regulate these issues? So we're going to start with Jonathan Adler, who's in the middle, who for many years was a professor at Case Western and really one of the country's leading scholars of environmental law, and then just recently moved to become the Cabell and Taylor professors. Somehow they wanted him so bad they gave him 2 endowed chairs, which should be illegal, I think, in most of it. But he has 2 endowed chairs at William and Mary. He just started there this last year. And then at the end of the panel, he'll be followed by Todd Zawicki, who is university professor at George Mason, which is their most distinguished chair, right, throughout the university. And he's going to speak. And then right next to me will be Mike Toth, who's the director of research here at the Civitas Institute, former Marine JAG officer, former general counsel of a company. So he's the only person on this panel who actually knows about the practice of law, and is also written, both litigated and written on these climate change cases. So Jonathan, why don't you take it away?
Great. Thank you. It's a pleasure to be here. Fun to be here on February 5th. It's the, I think, 55th anniversary of the Apollo 14 moonwalk is today. And for those who celebrate it, it's also the NBA trade deadline. I think there's about an hour left or so. But last I heard, Giannis is not moving. But in terms of our topic on climate litigation, what I wanted to do as an initial matter is put some of this climate litigation in a context in terms of the history of environmental law as a way of understanding it as a broader phenomenon, and then to say a little bit about some of the legal issues at the larger level, not in terms of the substance of the suits themselves, but the legal issues about whether or not suits like this should be allowed to proceed, and then they'll probably say some things about why I'm wrong, and then we'll have a fun discussion. So as we all know, there's over the last decade, there has been a rash of suits filed by state and local governments, with one exception, all in state court under state law, and we'll get to why those two things matter, seeking compensation from fossil fuel companies under various tort theories for the costs imposed on state and local governments by climate change. And these are mostly kind of adaptation costs or disaster response costs, things of that nature. And that's where, at least in the United States, the bulk of serious non-administrative law or non-regulatory climate litigation is. That is to say, there's obviously litigation with the federal government over regulations that agencies are adopting or rescinding and so on. And that litigation is always very serious and worth focusing on. And then there are a lot of other suits that are out there that are really kind of symbolic exercises, or things that are about generating press coverage or 60 Minutes appearances, but aren't actually about achieving anything in the courts of law as opposed to the courts of public opinion. And those sorts of suits are things like the kids' climate cases, right, which generate lots of fawning press coverage, but legally are quite bonkers and have no real anchoring in existing doctrine. Now, in terms of thinking about how climate litigation relates to environmental law more broadly, I think it's important to think about the history of environmental law. And we tend to talk as if environmental law kind of emerges in the 1970s. When, we have the first Earth Day, and Congress enacts all these various federal statutes, and that's the birth of environmental law. But that's actually not the birth of environmental law. The environmental law, as we should really think about it, goes back to at least the 17th century. And it wasn't obviously Congress. It was individuals, landowners, communities, seeking to use courts to protect persons and property from the other uses of property that might cause them harm. So the first reported case that we know of is a case called William Aldred's case, and it's a scenario that we could imagine, right? There's a landowner, and his neighbor is raising hogs, and the landowner doesn't like the smells and odors and waste generated by his neighbor, and so he sues in nuisance. And as you might expect, and this is again something we're quite used to, the hog farmer's response is, hey, wait a second. I'm producing food for the community. I'm generating economic value. You know, don't have so sensitive a nose because I'm doing something that's really valuable. And the court says, well, you know, that may all be true, but as a matter of law, the issue is what the rights are, not some net welfare calculation. And every landowner has the right to use their property in a way that does not interfere with or prevent their neighbors from making equivalent use of their property. So raise all the hogs you want, but don't do it in a way that effectively ousts somebody from their home. And so the sic udere principle, which we see in nuisance as the foundation of nuisance law, traces back at least as far as that case. There's some reason to believe you can actually go a few hundred years earlier than that. In the Anglo-American legal tradition, in the early history of the United States, that environmental law is primarily things like nuisance actions, trespass actions, one landowner perhaps suing another landowner for making a land modification that causes flooding or things like that. And the idea that there were remedies like that was well understood. And once the Constitution is ratified, we see this also across state lines, mostly in the Supreme Court's original jurisdiction, but downwind or downstream states litigating against upwind or upstream states over things occurring within those states that cause them harm. In the progressive era, the smoke control movement, the movement that ultimately leads to the first burst of air pollution legislation, is actually initially a nuisance movement, a movement seeking to file nuisance actions against coal factories or other facilities burning coal in cities to force them to either change their behavior or to move outside of town where they would not pose the same risk to neighboring landowners. Now, over time, we begin to see legislation adopted, initially at the state and local level first, well before it gets adopted at the national level. In fact, both air pollution and water pollution levels were declining before the federal government enacts its 1970s legislation, something that we often forget. And it was done for a variety of reasons, including the fact that we thought that having clear rules that were predictable, that were understandable, that were applied consistently might be better than rolling the dice on litigation and figuring out who could sue who, where, and when. And so that's why we saw at the state and local level, we saw legislation initially supplementing common law nuisance actions and the like, and eventually in some cases supplanting it. And that's also what we see when we move to the federal level. The federal legislation in part also having the aim of tamping down on variable state legislation. What's interesting in this area, especially in the context of air pollution and what ultimately leads to things related to the Clean Air Act and greenhouse gas emissions, is that when Congress enacts its legislation, such as the 1970 Clean Air Act, it expressly says that it is not preempting state law that aims to control the pollutants that Congress is going to control. The language that we often use is that Congress was enacting a floor, not a ceiling, and states and localities would still be free to do more than what Congress required. We can argue as a matter of political economy whether that's the way federal statutes actually work in practice. That is to say, sometimes creating a floor can actually act as a de facto ceiling, but as a legal matter, in terms of what states are legally allowed to do, when we look at the pollution control statutes, we see relatively little preemption in those statutes, and we see that explicitly by choice. That is to say, the Clean Air Act, Clean Water Act, and the like have savings clauses that expressly say, we're leaving everything alone. And the few exceptions tend to be things like product standards, where there was a specific concern about the ability to sell products in national markets. So, for example, the most prominent exception in the Clean Air Act is the preemption of variable state standards for automobiles, which was done because, not because states were going to do too little, but because there was a fear in Congress that states were going to do too much. That once California adopted vehicle standards in the 1960s, that other states were going to follow suit, and the automakers didn't like that. Now, something else that happens after the federal government enacts its statutes is that the Supreme Court concludes that it would prefer not to have these cases come before it, and not to have to hear cases in original jurisdiction of a downwind or a downstream jurisdiction suing an upstream or an upwind jurisdiction. And so the Supreme Court announces that under Erie, and we can get into Erie if we want later on, that's for the true legal nerds among us. The Supreme Court decides that these cases, insofar as they rely upon federal common law is displaced because the choice of federal law for dealing with pollution problems is that which is provided by statute, not that which is would be provided by the federal common law. But it's important to recognize that what the Supreme Court says explicitly is that this is displacement, this is not preemption. This is a choice of law rule, this is not a voiding or rendering inoperative rule. The idea under Erie is that federal common law is disfavored, and anytime Congress gives us an excuse to rely on a statute as opposed to federal common law, we should take it. The Supreme Court says that's going to be the rule for interstate pollution, but then says explicitly that that suits can still be brought under state law for transboundary pollution, provided that, at least if it's nuisance litigation, that the law of the source state is applied as opposed to the law of the downstream or the polluted state. And that's essentially a way to prevent opportunistic behavior. And in a case called International Paper versus Ouellette, the Supreme Court affirms that. This was folks in Ouellette were suing International Paper for cross-boundary pollution, and that suit goes forward under state law. International Paper ultimately settles that case for both air and water pollution for a substantial amount of money after it's remanded from the Supreme Court. Why do I give all this history? Well, because the climate change cases are being brought against greenhouse gases, emissions that are, as a consequence of the Massachusetts versus EPA decision, subject to regulation under the Clean Air Act. That I'm one of those who thinks that decision was wrong, but you know, that opinion and $3 will get you an overpriced coffee drink. The Supreme Court has concluded otherwise, and the claim has been made, and the Trump administration makes the claim, and fossil fuel company defendants have made the claim that because greenhouse gases are regulated under the Clean Air Act, these sorts of suits should not be able to be filed. The problem, of course, is that while these suits under federal common law would be displaced, as the Supreme Court held in a case called American Electric Power versus Connecticut, under International Paper and the other relevant precedents, they are not preempted and they can proceed under state law. Now, this does not mean the cases are sound. It does not mean the tort theories deserve to win. It does not mean the juries can or should find in favor of it. It doesn't even mean necessarily that these cases are consistent with the state laws under which they're being filed. All it means is that there's no legal basis at the front end to say that these cases are preempted and have to go away now. And that's currently the legal battle we're in. And just, you know, why do we say that? Well, because for something to be preempted of this nature, it requires Congress to actually preempt it. As Justice Gorsuch put it in a recent case, courts are hardly free to extend a federal statute to a sphere Congress was well aware of but chose to leave alone. Congress was aware of the long history of using tort law and nuisance law as the primary mechanism and source of redress for pollution, including for transboundary pollution. It chose to leave that alone, and unless and until Congress revisits that choice, these cases are going to be and should be with us and will bounce around unless until they either peter out on their own, they are settled, or Congress decides to legislate. Thank you.
It's great to be here in Austin because it brings back a memory of when I was clerking on the Fifth Circuit for Jerry Smith a few years ago, more than a few years ago. But we actually had a sitting here in Austin where we sat with the brand new minted judge at that point, Judge Benavides, and then the legendary E. Grady Jolly from Mississippi. And we had this case where this lawyer was making an argument. I don't remember the details of the case, but the argument was essentially went like this, which is if you read this statute in this particular kind of way, and you read the case law in this way, and the exception in this way, and the facts of this way, we clearly win the case. And so it goes on and on and on. And finally, Judge Jolly leans forward and says, counsel, you do realize that the biggest obstacle to you winning this case is the complete absurdity of your argument. The point being that when a law or a legal doctrine sounds absurd, it probably is, and it's highly unlikely that over the long run the courts are going to adopt this. So I'm not going to quibble with Jonathan's description of maybe what the best reading of the law is. We can have that debate separate. Maybe that is the best reading of the law. What I am going to say, though, is it's not the only reading of the law. I think there's another reading that is, I think, at least as plausible, but certainly plausible, and it actually comes out with a result that makes sense and doesn't lead us down this absurd path. So, and this isn't for Jonathan. I'm not doubting his legal acumen and how he's parsing the case law. Let me make that clear. I just think there's another way of reading all this that's much more plausible, that courts are much more likely in the real world to grown-up courts at least are to apply. So let's apply the Grady-Jolly test to think about where this particular reading might lead us. And where does it lead us? So let's focus on the Colorado case in Boulder, right? I spent a semester in Colorado as a professor at University of Colorado. And, you know, Boulder's exactly what you think it is. It's a hippie town full of very wealthy hippies who basically live in a utopian community where they think food comes from the grocery store and energy just falls from the sky. I think we saw how sort of policymaking is made in Colorado recently if you followed the recent power outages, which are not outages, but basically the power company in Colorado shut in the middle of a very cold spell, shut off the power for 4 days to everybody's houses, right? Because a few years ago there had been all these fires. The energy company was held liable for it, even though it's not clear that they actually caused it, but you know they were held liable for it. And so because there were high winds and it was very dry, so it's very cold, it's very dry. They had high winds. They shut down in the middle of a sub-zero, several-day cold front, all the electricity in Boulder. Now, why did that matter? Well, because Boulder, in their magical thinking, had basically said, we're going to get rid of all gas stoves, we're going to get rid of all gas power, right? So basically, you had people sitting in the cold, they couldn't start their cars, right, because they all had electric cars, right? And this is the world in which these people occupy, right? And these are the people now, this is the county that has decided to bring this lawsuit. Now, one of the things I find amusing about this lawsuit is we always hear climate change is an existential threat to the world. The biggest thing they seem to be focused on in Boulder, from what I could tell, is it will cost more for us to maintain the roads now because of the rain and frost that'll come with it, which I think is pretty amusing, right? But think about this. If Boulder can do this, Austin can do this, Falls Church City can do this, San Francisco can do this. Basically, anybody anywhere can bring one of these cockamamie lawsuits under this. And some of these lawsuits, I mean, Jonathan just brushed over them. I think there's one now, I don't know if you've heard about this one, in Oregon, which is basically climate murder. Have you heard of this one? Somebody suing now for wrongful death because of somebody died supposedly because of heat in Oregon caused by this, right? I mean, we're talking about these crazy things, right? But, you know, it's pretty clear this could unleash literally any community in America could sue any of these companies. But why stop the power companies? Why not sue airlines, right? Fossil fuel companies, airlines, anybody who emits it, you could blame them, right? But why stop at fossil fuels? You know, we all know every form of energy creates some sort of externality. Solar panels, Wind power, right? We all know, more than I ever thought we would know, about the psychological health of whales related to wind power. Why not, right? Why don't we just sue all of this, right? Airlines, trucks, anything that you could do, right? And I would say there is a pretty big difference, maybe you disagree, but I would say it's a difference in kind, not just degree, between some guy who wants to run a pigsty in a residential neighborhood and the ability to re-engineer the entire American economy and society with all the implications that go along with trying to manufacture energy policy through some judge in Colorado in state court, right? These are complicated sort of trade-offs, and I just don't think it makes any sense to think that the common law or any judge thinks that this makes sense, right? I mean, we're talking about, as we heard on the last panel, we're talking about energy, which has been, along with the rule of law, I would say, probably the single greatest thing that has lifted billions of people out of poverty around the world. I heard a fascinating speech by Maguette Wade from Africa a few years ago, who talks about what it's like to be poor in Africa without access to low-cost energy. She says, basically, women in Africa spend hours every day basically collecting wood to be able to heat up water so that they can cook, they can bathe, and do all those sorts of things, right? According to the World Health Organization, I couldn't find a really credible organization, so I had to rely on the WHO. But according to the World Health Organization, that there are 2 billion people in the world who rely on indoor cooking fires, which is they yak dung, they burn dung, they burn wood. It's estimated about 3 million people around the world die prematurely every year because they have to do indoor cooking, because they have to burn these sorts of effluents in their house, especially kids, right? This is really, in my view, vicious, anti-human policies. I mean, it's just unimaginable to me that Tom Steyer is flying around on his jet thinking that this is a way to improve the world by doing this sort of stuff. Before petroleum, we also had externalities, right? As you probably know, New York City used to run with horse crap every time it rained. Do you know why why brownstones are walk-ups in New York? Because the rich people could actually afford to elevate their houses off the street so that they didn't get so much horse crap when it rained, and the poor people couldn't. All those forests in New England are all new growth forests. Why? Because that all used to be farms where they would grow hay to feed the horses in New York, Boston, Providence, and in places like that, right? We're talking about complex trade-offs that just are not possible to be made by random judges who aren't taking into account all these sorts of things. Now, fortunately, it turns out we don't have to go on the Jolly test and to take the absurd reading. I think the dissent in the Colorado case provides a perfectly plausible and certainly, I think, more reasonable reading of what all this is. Basically, what they said is you don't ask whether the Clean Air Act preempted state lawsuits. You ask whether the Clean Air Act authorizes state tort lawsuits. Now, why do they say that? Because prior to the Clean Air Act, there was no state tort law, right? Prior to the Clean Air Act, they say these were primarily a matter of federal common law because this was a uniquely federal interest to deal with these sorts of interstate type things. And so I'll just quote a couple money paragraphs. Had Boulder's state law claims been raised prior to the Clean Air Act's enactment, they would have been precluded under federal common law. And simply because federal common law related to greenhouse gas emissions has been displaced by statute doesn't mean that the conditions that made state law inappropriate to govern these claims in the past have vanished into thin air. In other words, Congress's decision to displace federal common law and take control of this area did not suddenly render state law competent to regulate interstate and international air pollution. Nothing in the Clean Air Act reflects that Congress intended the result the majority reaches here. Unlike the blue fairy that brought Pinocchio to life, The Clean Air Act did not magically breathe life into state law tort claims that had been lifeless as a wooden puppet, right? Now, they go through the history. Again, I'm not going to argue right here. It's the only reading of the history. But it sure as heck is a more plausible reading of what Congress enacted. The idea that Congress in 1955 and 1970 all of a sudden passed a completely comprehensive regulatory structure, and then, without ever mentioning it, said, and then the states can come along, or then private billionaires could come along and fund litigation to allow states to just state judges to re-engineer the entire economy. And there's no evidence in the Clean Air Act to suggest that that's what they were doing, creating this duplicative, massive type system. And so it seems to me, if we apply the Jolly test and we apply standard methods of legal analysis, it seems obvious to me that what we're talking about here is not a sustainable system. If it is, then I would encourage anybody to start bringing lawsuits against solar panel manufacturers, against windmills, against everything the green people love. And if you can figure out a way to do your own consumer fraud claims against people like Tom Steyer and the groups that are pushing this idea of existential threat that we have to sacrifice millions of people to poverty and early death because of the possibility of global warming, that sounds like fraud to me. So I would say if you can't beat them, join them. Thanks.
Wonderful. Not surprisingly, with four attorneys on the panel, you're going to get 5 different opinions on the matter. So I'll sort of pick up, I guess, where Professor Zwicky left off on kind of the legal issues or the legal defects that I see with the municipal climate cases. Not so much with the earlier part of what Professor Zwicky talked about, though I will note it's not simply a matter of one subjective view as to the quality of these cases, and I think Professor Adler did a nice job when he touched on this earlier in his remarks, but the reality is in state courts, these cases have been on a losing streak. And so just in the past 18 months in Pennsylvania, in Maryland, in New Jersey, in Charleston, South Carolina, these cases have been found to be not viable. And I think some of the tenor of the state court judges, not necessarily on the issues that we're going to be talking about during this panel, but the state court judges, I think, have sort of had the same kind of mental block that Professor Zwicky pointed out earlier in his talk of, you're asking us to do way too much here at the state court level. So I do want to make that point, but I want to pivot more importantly, which is what we're all focused on, which I see to be the legal defects of these current cases. And I'm just going to say 3. First and foremost, the case that Professor Adler talked about as being a viable case under the Willett decision of 1987 does not exist. There is no case that's pending that is a Willett case from 1987, and I'll touch on that for a couple minutes. So primarily, if we look at the cases that are pending, the municipal cases that are pending, they're different in a very substantial way from the Willett case. That case isn't one of the cases that we're going to talk about. So that's first and foremost. Secondly, if you look at the municipal climate cases, there's a structural constitutional problem. John referred to it earlier in that the cases are seeking state courts to essentially make foreign policy. I'll get to that as point 2. And then point 3 is some of what Professor Zwicky touched on in terms of the Clean Air Act. Though you don't have to quote a dissent, it's a very good dissent, and I agree with you, the dissent from the Colorado case is worth reading, whether you agree with it or not. Actually, a 9-0 Supreme Court decision from Justice Ginsburg, the AEP case, actually distills the history of the Clean Air Act in a way that I think is dispositive on the matter. So 3 reasons. First is the case are not a Willett case. Second, the global issue. And then third and final is sort of the Supreme Court precedent interpreting the Clean Air Act. First and foremost, on the Willett case, just so we're clear, the Willett case was a case where the U.S. Supreme Court resolved that class action of residents of Vermont could sue the International Paper Company, but only under New York law, because New York was the state that had given the permit to the International Paper Company. And therefore, the state law that applied from the Supreme Court's perspective was New York law. And the Supreme Court specifically said they could not bring a lawsuit under Vermont law. If you look at the two cases that are pending, the Colorado case as well as the Hawaii case, they're not trying to apply Texas law to Texas emissions. They're not trying to apply Nigerian law to Nigerian emissions. They're not trying to apply West Virginia law to West Virginia emissions. They're doing exactly what the Supreme Court in Willett said you can't do. They're seeking the court to apply Hawaii law to emissions in 49 other states and 190 countries around the world, which is precisely what the Supreme Court said you cannot do. Now, the U.S. Supreme Court, apart from a very tiny handful of cases, is a court of appellate jurisdiction. It's not a court of original jurisdiction, which is to say it can't rewrite it can only take an appeal based on the case that is actually pled, right? And so the cases that are actually pled, that are live, are not Willett cases. They're precisely different from Willett cases. And just an additional point on this, I think that really makes it abundantly clear, is there was one potential Willett case that was brought by the climate groups that have been supportive of the Hawaii case, which is pending, as well as the Colorado cases and the other ones that have not gone their way, which was a Delaware state court case. And in the Delaware state court case, as with the others, the plaintiffs wanted to apply Delaware law to emissions in every country of the world, right? Delaware law to every other state of the United States, and also Delaware law to emissions in the state of Delaware. The court dismissed the application or attempted application of Delaware law to the out-of-state and international emissions, but said you can continue to plead this case and take on Delaware emissions under Delaware law. And the plaintiff said, no, we don't want that. So the plaintiffs are primarily interested in applying their own state law to emissions outside of the state, which is, again, not the Willett fact pattern. And I think that's very important. I'll give one very practical reason. If you think about the company in the Willett case, they got a permit from the state of New York, which was pursuant to the Clean Water Act. If that company felt like the permit wasn't the right permit for the kind of emissions they wanted to do, in the ordinary course of things, they could talk to the regulators of the state. They could get a different permit, right? And if they didn't like what the regulators were telling them in terms of what the regulators were willing to permit, they could go to another state. They could leave New York and find a different state that may give them a permit so they could move their business, hire their employees, provide the services and the goods that they're providing to the economy. If you don't do what the Supreme Court allows under Willett, and you do what the Supreme Court specifically prohibited under Willett, you get a situation where it's like Hotel California, and you can never check out, right? So if Hawaii law applies to you, as long as there's personal jurisdiction, some minimal contact, you could have no business in Hawaii, you could have no sales in Hawaii, you could purposely decide, I don't want to do business there because I can't comply with the regulatory climate, I'll go somewhere else. But you're still subject to Hawaii law, right? And that's a major horizontal federalism problem. It's putting Hawaii in charge of national policy, right? So that's why it's a very important problem in terms of the difference between the case that doesn't exist and the Willett case. My first point, second point, just second and third point, very briefly, because we do want to get to questions. On the global point, oftentimes I think attorneys, when they talk about these cases, they go right from, the fact that these are seeking to apply one state law to the other 49 states. They go right to that point. But these cases are about global emissions. And I know there's a lot of individuals who have studied the oil and gas industry or in the oil and gas industry. Are most emissions inside the United States or outside the United States? Right? Overwhelmingly outside the United States. Close to 90%, according to the International Energy Agency, close to 90% of emissions are international. And actually the trend is towards international, not towards national. If you go back to the year 2000, the US made up about a quarter. Now it's closer to 10%. The developing world, due to the global surge in energy demand, is seeking more energy, more emissions, right? If you look at some of the companies that have been sued, and this is just public documents. If you look at Shell's website, company reports, they provide their products to over 30 million customers. over 30 million customers in 70 different countries. They report that upwards of 80% of their emissions are from outside the United States, et cetera, and so forth. So, as Willie Sutton said, right, why do we rob banks? That's where the money is. The money in these cases is outside the United States, right? So what we're fundamentally doing in these cases, 80, 90% of the prospective liability, is we're asking a state court to affect our foreign policy, right? We are, our energy exports to Europe increased 3 times after of liquid natural gas after the Russian invasion of the Ukraine. Now we're going to have a state court judge who's going to make energy products more expensive, right? It's going to affect that foreign policy. Our energy exports to developing countries is increasing. We're going to have a state court judge who's going to interfere with that, right? So there's a long list of Supreme Court cases where the Supreme Court has said, issues that touch on federal affairs are the province of the federal government, not of the state court, not of the state government, and certainly not of state courts. And they've said that in cases where there's a lot less interference with foreign relations and international affairs than what we're seeing here. And again, like John, you said earlier, wherever one falls in terms of the first panelist who presented, there is a fundamental question about what level of government, and I think everything from the Clear Air Act to the Supreme Court cases really points to the executive branch, the political branches, making these kinds of very important decisions with regard to our international partners. And then finally, just on the Supreme Court case, as I mentioned before, Justice Ginsburg in the AEP case, really points out that the standard for looking at interstate emissions is federal law, it's federal common law. Federal common law means that, there is not state law that's operating. There's a quote from Milwaukee 1, which is a Supreme Court decision from before the Ginsburg opinion. When we deal with air and water and their ambient or interstate aspects, right, that's what we're talking about with greenhouse gas, there is federal common law, Milwaukee 2. Federal common law exists, it's because state law cannot be used. And, Ruth Bader Ginsburg, in the opinion from the court, unanimous court, says environmental protection is in the national scope. The court says in particular at the end of the opinion, and I think this is a very important point, at the end of the opinion in AEP, the court says, okay, well, there's one issue that we're not deciding. What precisely does Justice Ginsburg say that they're not deciding? The relief under state law, in particular the law of each state where the defendants operate the power plants. In other words, in the source state. Right, so Justice Ginsburg in that last issue, in that last paragraph, simply says that the only thing that state law might be able to do is what happened in the Willett case, which is to use state law to focus on, the state law of the source state to focus on emissions there, which is, again, not what we have in any of the municipal climate cases, all of which that are live are seeking to apply the state law of the forum to emissions all around the country and all around the world, which is precisely what the court in Willett and then again in AEP said can't happen, and it creates these structural problems with the Constitution, et cetera, and so forth. So I think there's numerous reasons why the cases are not ultimately going to be successful in the state court system.
Great, so let me start off the question and answer by turning to Jonathan, who might also want to use this time to reply to some of the responses to his presentation. So, Jonathan, I wanted to know what you think the optimal arrangement for government decision of these questions were to be if you were in charge. So your presentation, I believe, was this is the way it is because of Supreme Court precedents. And I think, right, Todd and Mike said, well, the law is arguably one way or the other, but the optimal way to decide this would be have a uniform federal policy. I couldn't tell from your presentation whether you agree or disagree. And then I think their secondary point was these causes of action at the state level are almost frivolous. It sounded like the idea that energy companies have a right to have to disclose climate change harms to everyone who buys oil and gas assumes that people don't know, right? That these harms are already included when you buy petroleum products. So I wanted to hear from you what your normative view is, rather your descriptive view.
So my normative view of the suits as a matter of tort laws, I'm very skeptical of them, both because of the type of attribution that has to be shown. I mean, so for example, an oral argument in the Seventh Circuit, I guess just 2 weeks ago, the plaintiffs acknowledge that for their consumer fraud claim to work, they have to show the climate impacts from the quantum of emissions, the marginal quantum of emissions that are a consequence of the consumer misrepresentation as a percentage of overall emissions, and then what those effects are in Illinois in the relevant time frame. And my read of the, not a scientist, but my read of the attribution literature is that would be a really heavy lift. But generally, when it comes to tort law, we let plaintiffs try and make their case, and if the attribution can be shown, it can be shown. In terms of at a policy level, if it were up to me, I would tell Congress, because that's where legislation comes from, not the executive, not the judiciary, to eliminate the stationary source provisions of the Clean Air Act's applicability to greenhouse gases, to preclude most of these suits for most of their effects, and to impose a revenue-neutral carbon tax and call it a day. If it were me, that's what I would do. I think that makes much more sense. The idea that courts can engage in that kind of judgment, I find to be the sort of claim that's just alien to our legal system. That is just not what judges, if litigation is allowing people to produce outcomes that, from a policy standpoint, we think is unwise or wasteful, legislatures retain the ability to preclude that. And the history of environmental law is filled with that, where we decide the litigation is either producing restricting private economic activity too much, or it's too variable, or it's too uncertain, or it's not protective enough of people and their properties. But that's a legislative choice. If we didn't have that, I happen to think the displacement doctrine that Milwaukee 2 invents and that American Electric Power is based upon is ahistorical and was made up. And there is nothing in the history of the Clean Air Act that suggests that Congress thought it was displacing anything. There is nothing in the original understanding of Article 3 that suggests Congress was displacing anything. It's a holdover of the Erie Revolution. And I think one of the more unfortunate aspects of it, the reality is that prior to that period of time, it wouldn't have even been federal common law. It would have been understood as the general law of nuisance applies across state lines, and those cases could be heard in the Supreme Court's original jurisdiction, as many were, or they could be heard in state courts or federal courts if federal courts were created. But we're a long way from that. But so I agree, as a practical matter, you want to deal with an environmental problem at the level where that environmental problem manifests itself. And if our current institutional structure isn't doing that, then we have proper ways of making that happen. And that's Congress going through bicameralism and presentment to enact a law, not trying to make these arguments for what are essentially preemption by penumbra, where we argue, well, we should be able to dismiss the case now because we think later on, when the court has to resolve the choice of law question in response to a motion on that issue by the defendants, or when the court is considering the damages, they might get the quantum wrong and they might award damages for things that weren't properly within that court's jurisdiction because it's a state court. Those are all interesting questions, but we don't resolve them at the front end of litigation. Those sorts of things aren't the basis for a motion to dismiss. Those are the basis for appeals to challenge the verdict. And so I understand those concerns about litigation. I think they're real concerns. They just have no place at the front end to try and preclude the plaintiffs from having any opportunity to bring them at all. That's why every federal circuit court that has heard the claim that these cases can only be brought and understood or cognizant under federal common law has rejected the claim. And these haven't been by crazy liberal judges. These are opinions by people like Stephanos Bibas of the Third Circuit or Professor Zawicki's former colleague Naomi Rao on the DC Circuit. They make it quite clear for these things to be preempted, Congress has to have preempted it. Justice Ginsburg also says that at the end of the American Electric Power case. She says state law cases are to be preempted. It's a function of the Clean Air Act and the statute. That's what Ouellette says. The permits were irrelevant in Ouellette. That's not a defense in a nuisance case in most jurisdictions. That is why on remand, when it went back to court to hear it under New York law, international paper settled for both air pollution and water pollution that it was causing to the folks in Vermont because it knew it had to answer for those claims. And so I think that the Colorado courts may think they're incompetent to hear, or Justice of the Colorado Supreme Court may think Colorado courts are incompetent to hear these sorts of claims. As a matter of Colorado law, might be perfectly correct. But as a matter of federal law, both as the way we originally understood courts to operate under Article 3 and state courts, which were the dominant courts, because right under Article 3, we don't have to have any lower federal courts. The original public meaning of Article 3 only requires a Supreme Court. It presumed that things could be brought in state court. Under that and under Supreme Court precedent, the plaintiffs get to take their shot. Again, I think it's a bad shot. I think it's a policy matter. It's a crazy way to try and deal with climate change. But that's not something, courts should not be resolving the, quote, complicated trade-offs that Professor Sawicki mentioned. They should be resolving claims based on the rights that people have. And if legislatures don't like that, legislatures can fix it.
Let me put the question to Todd and Mike in a way that is your question in your response, but maybe for people who aren't, didn't have to go through 3 years of law school might understand, which is basically what Jonathan's response is what's wrong with just the regular way we make policy? Why don't we just use that for, the regular way we make policy is generally the states regulate everything unless the federal government chooses to act in those specialized areas which are within federal jurisdiction. Here, Jonathan says Congress has not acted. And so the general presumption we have in all law is we let the states regulate, and why don't you trust the states? We have a system of federalism where, we're in Texas right now, which has very different policies on the environment than California, where unfortunately I'm still rooted. Because of that, I pay different income tax. I have different environmental. Why don't we allow competition and policy variability that we apply for everything from the death penalty, right, to euthanasia and on and on? Why don't we use that for the environment too? That's Jonathan's challenge, I think, to both of you, is what's wrong with the regular way we make policy for these kinds of lawsuits and these kinds of questions?
Yeah, because this is exactly not that situation, right? This is Boulder, Colorado, claiming to make policy for the entire country, right? It's not a zoning decision in Berkeley that has no impact on Texas.
We don't have zoning anymore.
You don't?
Actually.
Oh, well,
no,
good,
because
good.
that stood in the way of multi-family apartment buildings.
Oh, good point, right. But there are things that are local, and that's what federalism is, right? This is the quintessential example of one state trying to control policy and outcomes in other states. States with very diverse populations, people with different preferences, people with different socioeconomic status, right? All these policies, like more expensive energy is highly regressive. I don't know if you know that, right? Older people drive older cars, they live further from work. It's not linear in terms of how much it costs to cook a plate of, cook a pot of spaghetti or heat your house or run your water heater, right? We've got those sorts of questions. We've got different priorities that different states have. And so this is the quintessential situation in which we understand that traditional federalism doesn't work, because fundamentally what they are doing is not regulating anything in Boulder. They're regulating the entire rest of the country to force everybody else in the country to subsidize the hippie effete sort of fantasies of Boulder people. That's a classic example where we don't trust federalism, and that's a classic example of why we've always had this situation, which we do have federal common law to deal with the situations where we do see these overlaps, or we do see these externalities, or we do try to see people regulating an activity in other states, and we don't trust a particular state's law or a particular state's court, especially elected judges, to be able to buy votes by basically catering to the people in their own states while imposing the cost on everybody else around the country to basically subsidize the things they're doing. And so, to the larger point, why don't we just let it play out? Yeah, these cases seem frivolous. They always seem frivolous until they're not, right? It only takes one judge. That crazy kids case in Montana, that was frivolous until they won, right? What we have here is the situation in which the entire rest of the American people have to rely on Exxon and these guys to win every single case, right? One case and it's over. everything else gets form shopped into that jurisdiction, one after another after another. And this is what they did in the tobacco litigation. The plaintiffs' lawyers got together, they filed exactly the same lawsuit in 10 states, they lost in 9, they won in 1, and form shopped everything into that, right? This is why it can't be the case we just let these cases run on and on and on, while guys like Tom Steyer and these other billionaires basically get their jollies by funding these environmental groups to just engage in endless litigation, endless theories, and we all understand litigation, the process is the punishment. I mean, millions of dollars. Basically, they've got unlimited funds. They've got unlimited billionaires who will fund these fantasy lawsuits, where just the cost of defending these by the energy companies means higher energy prices, less money for exploration, less money for innovation, all the things that we need. Simply the litigation, the millions of dollars of litigation costs that they're imposing on the rest of us affects our quality of life. And so I think this is a classic situation where where people need to understand, even if this is frivolous litigation, they don't care. The process is the punishment. They'll just keep bringing these cases over and over and over, and they'll find deep-pocketed people like who will continue to fund these situations, and just that process itself is making all the rest of us poor.
Yeah, and I would just add to that. As I said earlier, 80 to 90% of emissions are international, and so what we're asking state courts to do is to set international policy. And there is a litany of U.S. Supreme Court cases that I think we can all appreciate that says state courts, their province is not to make international policies, it's not to deal with international relations, it's not to deal with foreign relations. Those powers belong to the federal government. There's a lot of people who would want the state of Texas making international policy. There's a lot of people who would want the state of California making international policy. What we have in the Constitution is a federal government to make international policy subject to elections every 4 years, right? And so there's major structural problems with the way these cases have been pled, and it's incumbent upon the parties bringing the cases to try to keep the cases alive and get them so that they can actually be adjudicated, and they haven't done that. That's the first point that I mentioned earlier, which is, again, if we look at Willett, if we look at this narrow gap that the Supreme Court left open, it was to bring cases under the law of where the emissions are happening, and there's not a single case that has been brought that has tried to do that. They've done the exact opposite. They're trying to apply the law of Hawaii or Colorado to emissions that are happening outside of the state and outside of the country, right? Which is precisely what Willett said that you can't do. And so they're not viable cases under existing precedent, right? So, what's incumbent upon parties that bring cases is to know the law and then conform to the law to the best you can to advance the case. And that hasn't even remotely, we're not even remotely close to that happening in these cases.
So we have about a little over 20 minutes left, so I'll invite questions from the audience. Before I do, I should have made 2 disclosures. One reason we're talking about this is the Supreme Court currently has pending on its docket this exact case, and it's trying to decide right now whether it will hear the, there have been cases out of Maryland, Colorado, Hawaii, they're all over. One of those cases, the Supreme Court denied cert last year, decided not to hear the case, but right now, at this very moment, they're deciding whether they're going to hear these cases. The second, I should have made clear, personally, I filed an amicus brief that the Supreme Court should hear that case with my podcast co-host, Richard Epstein. So if any of you know Richard Epstein, it's not a question of whether you're going to file a brief at the Supreme Court. It's a question of whether you can stop Richard Epstein from filing a brief at the Supreme Court. And so we filed a brief. I mean, I think he's one of the great tort scholars of our time, and he has very strong views. Again, when does Richard not have strong views? He has very strong views about the tort case, so we decided to throw an amicus brief in together saying the Supreme Court at least step in and resolve these issues, one way or the other. So let me take questions. Steve?
So, in the last couple of years, the issue of climate change and mitigation has declined in salience, certainly in the popular discussion, and to a large extent in the political discussion. One might be tempted to blame the present administration for that, but in fact it's international, and there are fundamental reasons why it should be happening. Do you think that shift will affect
So the question, if I is just, do you think the public's interest or the political salience of climate change, global warming, whatever you want to call it, is going to affect maybe the Supreme Court's decision whether to intervene, or the way the lower courts are answering these questions?
I mean, my view is, yeah, I don't, I mean, one thing that's interesting is these cases, unlike some earlier cases, of which AEP was representative of, which sought injunctive relief, sought orders to actually require emitters to emit less, these are about damages. So these are arguably about adaptation, not mitigation. So in that sense, that's also an interesting shift that the litigation has moved in that way. As I mentioned earlier, we still have things like the kids' climate cases, but those are PR cases. Those aren't, as a legal matter, those aren't serious. It shouldn't affect the court. I don't, you know, does it affect whether the court will grant the case? It might. I mean, my own view of this is that the current court doesn't like preemption. It doesn't like the Dormant Commerce Clause, which would be another way to try and make these cases go away without statutory preemption. But if California is allowed to effectively set pig treatment standards for the country, it's not clear that the Dormant Commerce Clause under current law is going to do much work there. The court, even when it takes tort cases that it feels it has to, it doesn't have a lot of enthusiasm for them. Last term, it took 2 securities law tort cases and then digged them after argument. That's the court basically saying, yeah, we thought we were going to resolve these cases, but they're too messy, and we're just going to, you know, never mind. We'll take a mulligan on having heard the case. So insofar as these cases, and the court recognizes these cases present messy questions about litigation at the front end of that litigation, I think the court is going to be reluctant to take them. I think that's why it's denied cert in all of the federal removal cases, petitions that have been filed, and I think there were 6 or 7 of those, and it's denied cert in the Honolulu case and the prior cases. The argument on the other side is there is arguably a circuit split, because there was a case in New York where the plaintiffs did some silly things that got them in front of the Second Circuit on a posture that wasn't great, and then the Second Circuit wrote, just as a matter of history and like factually recounting the structure of our government, a horribly wrong opinion. But that gives enough of a circuit split that if the court wants to take it, they might. But I don't think they like the idea of being the entity that decides when tort litigation is a good or a bad idea. I think they like the idea that if Congress thinks these cases are bad, they should do, for example, what they did with the gun industry, right? So Congress enacted I always get the name of the statute wrong, the Protection of Lawful Commerce and Arms Act. Why? Because creative nonprofits and plaintiffs' lawyers were bankrolled by rich billionaires to file lots of lawsuits to try and bankrupt gun manufacturers. And Congress figured that the process was a punishment. Congress did what Congress is supposed to do, which enact legislation and say, let's make these cases go away. The Supreme Court just heard a case last term shutting the door on an attempt to get around that statute. I think that the court prefers that. If the court thinks that Congress just can't get its act together, maybe it'll think it has to intervene. But that's my take on it.
Todd, does the Supreme Court read the newspaper headlines too, just like everybody else? And will it affect their decision on whether to intervene in these cases?
Yeah, I think so. I mean, I think in Jonathan, or Michael may know, maybe Jonathan sees like, but there is a fundamental issue here, which is when I read the briefs by these plaintiffs, they just have made no effort to respond to this feeding frenzy problem, right? This pig pile problem of everybody in the world being, you know, every municipality, everybody cooking up some lawsuit with just redundant litigation over and over and over and over and over and over and over, right? And then cooking up these various different things and basically filing 1 and then 10 and then 100 and then 1,000 of these cookie cutter lawsuits in different jurisdictions and the like. And if they can't come up with some plausible explanation for why we're not going to have this feeding frenzy, it just strikes me that Supreme Court can't be that dumb, right? It just can't be that they leave that door open to that. And so if they come up with some plausible way of doing that, which as far as I know, maybe Jonathan see, but as far as I know, they haven't, I don't think they will because they want to be able to do that. They need to do it. I think it's been pretty clear that the cost of this become more apparent, right? You know, basically Europe destroying its own economy and helping our manufacturing base with their idiotic policies. That's why Europe doesn't want it. It's pretty clear we don't want it. I do think one of the problems, and Jonathan mentioned briefly, and I want to elaborate on something he said, was that EPA versus Massachusetts case was a really bad decision that I think is kind of a clunker in the middle of this, where they have this sort of whole coherent idea of major question doctrines and stuff. And so in EPA versus Brown and Williamson, for example, the court said, the Congress has known for a long time about tobacco, and they chose not to regulate it. The FDI can't regulate it. EPA versus Mass seems to be exactly the opposite, which they said, people for a long time been wanting to do this. Congress has chosen not to do this, and so we need to make them do it, essentially, right? And that one case is kind of a clunker in all this. And so how this might fit with those questions about the major question doctrine, what Congress intended with the Clean Air Act, and a lot of this background we've been talking about, I think might be part of this as well.
Okay, good. Steve Hayward? If people couldn't hear that, Steve asking, do you detect any kind of interest on the Supreme Court to overturn Massachusetts versus EPA? For those who don't follow this closely, Massachusetts versus EPA was a case where the Supreme Court said under the, I hate saying the name of the statute, the Clean Air Act, under the Clean Air Act, the EPA must regulate greenhouse gases. not say the word Clean Air Act. But whether there was like a statutory obligation in a way for the EPA to set some kind of regulation for greenhouse gases, as you may know, before this decision, the EPA chose not to.
Right.
Yeah.
They won't overturn it because it's a statutory decision. So generally, statutory stare decisis is the strongest form of stare decisis. The idea being that if the court misreads a statute, Congress is fully capable of changing it. There are other things about Mass versus EPA that the court has either already cut back on. So in a case called UARG, it basically said we're gonna confine the damage. In that case, at oral argument, Chief Justice Roberts actually asks UARG's attorney, "You're not asking us to overturn Mass versus EPA, are you? Because we don't do that." He says that at argument. UARG can kind of confine the damage in that respect. The standing decision of Mass versus EPA. Right, so the question of what does a litigant have to show to get into court, in particular a court, into federal court under a federal statute, that the court might revisit, right, because that's a constitutional question, and the court, I think, is very unhappy with current standing doctrine and the fact that it has led to a proliferation of lots of types of litigation that the court thinks should go away. But the underlying Mass versus EPA holding, I don't think they'll overturn it. Last thing I'll note, though, if they overturn it, then AEP versus Connecticut goes with it. Because AEP versus Connecticut is based upon greenhouse gases being subject to regulation under the Clean Air Act. And if you take that away in Mass versus EPA, well then federal common law for greenhouse gases is back and we don't even have to talk about state law.
Yeah, my sense is that they've kind of treated Massachusetts EPA as kind of an embarrassment. At least when I read these major question doctrines case, they kind of pretend like it doesn't even exist. They hardly mention it. They don't even try to distinguish it. They're just kind of going to leave it there, nip it away, keep it as narrow as it is, and just pretend like they never really did that. Is my impression. But it does. I was just sort of yeah. So.
Well, I think I'll just say one thing on top of it all. I agree with the sort of prediction on Mass v. EPA. If Mass v. EPA is still the law, and we have a situation, and this kind of gets to Steve Kunin's question from before, where a state court, whether Colorado or Hawaii, actually tries one of these cases, I think at that point you will see an appeal to the Supreme Court, and the Supreme Court, if there is a finding of liability at the state level, will reverse it. And the reason why the Supreme Court will reverse it, and appreciate Professor Zwiecki's comment on the sort of preemption point in terms of the justices, but I think fundamentally it's not a preemption case, right? I mean, if you look at the sort of analytical thrust of what I see in the Ginsburg opinion from AAP, she makes the point very clear, the baseline, the framework for interstate, international emissions is federal, right? That is the baseline, and then the Clean Air Act provides further detail on top of it, right? So it's not a matter of preemption where you have a state law that a federal law knocks out. You didn't have the state law to begin with, which is how Ginsburg structures a unanimous opinion for the Supreme Court. So I think if there is a finding of liability, I think the court will then take the case. And then, Steve, I think your points about the world around us really become important, right? The trend is towards more international emissions, right? So we would have a state court basically regulating more and more and more of what's going on outside the United States. You've got, obviously when the Russian tanks rolled into the Ukraine, that was an inflection point. That was 2022. That's before the current administration. That changed the world's views on international energy markets, on international energy production. That changed Europe's views on those matters. That changed international finance's view on that matter. The more that the U.S. Supreme Court sees state courts dominating national affairs, I think the clearer it becomes this is a problem that they're going to address. Right over here.
I mean, there are clean hands defenses that the defendants could raise, but they're not waiting for the opportunity to raise them, right? So there are various legal doctrines that make it hard for you to seek redress from somebody that's doing the same conduct that you're doing, right? So there's this equitable notion of kind of like reciprocity. There are all sorts of defenses like that can be raised in the context of these cases, including defenses also about right? So all of the defendants are present in the jurisdictions where they're being sued and have activities in the jurisdictions they're being sued, and some of the conduct for which they're being sued for is that. The plaintiffs, when they file their complaints and file their lawsuits, the way plaintiffs always do, leave as many options open as possible to force the defendants to narrow the scope of the suit as it goes along, right? This isn't new to climate litigation. These issues were litigated in the MTBE litigation, for example. MTBE was a fuel additive that was designed to reduce oxygen content or to increase oxygen content in fuels, but it also tends to make a mess of groundwater. And so the courts had to deal with the same sorts of things. Do we have jurisdiction over the MTBE added just in our state or just in this county or next door? Does it matter what ship? And that's all stuff that has to get worked out. But that's all stuff that gets worked out in the course of litigation. The fact that those things are problematic and difficult have never before now been used as an argument for dismissing the cases on the front end, right? The idea that you could dismiss the cases on the front end on those bases is something that was essentially invented in this litigation, or it's been tried a couple times, but it's never been successful, and the first time we've ever gotten any biting on that sort of thing has been in this litigation. But the reality is, right, Boulder presumably will have to show, okay, we have jurisdiction over this company and over this proportion of the company's activities and this proportion of emissions, and then they're going to have to show. And the more and more they have to do that, the more I think most of us in this room would say, yeah, like a court's going to think that can be shown with a preponderance of evidence. I think no, because it just becomes too speculative. But in our system, unless the legislature wants to come in and say enough is enough, we let plaintiffs try and make their case. And the history of environmental law is plaintiffs trying to make their cases, and some of them succeeding when people thought they were going to be wrong. And in retrospect, when we look back, we say, thank goodness, because that plaintiff actually recognized an environmental harm that the rest of the world was going to ignore, and thank goodness they brought a suit and helped to educate us and inform us. And if legislatures think that's leading to bad policy results, as we've heard lots about, legislatures remain free to do that. If David Bookbinder were here, he was originally going to be honest, he would make an argument that that some of the legislative solutions would produce takings. That's a fun argument, but that I'm not sure how far that would go. But as a realistic matter, right, Congress could tomorrow, if it wants, make all these cases go away. You know, why hasn't that legislation been introduced? Why isn't the president talking about the need for that legislation? Why aren't committees holding hearings on that legislation? Why aren't they doing their job? Why are they instead asking courts to play policymaker?
Yeah, I'll just add, I mean, one of the things that's interesting, one of the things that's interesting is how slick these theories are of these lawyers, right? They just kind of move from one theory to another. So, you know, the obvious point is, you know, on the policy thing is these are huge questions, complex trade-offs, cost benefits, all these different sorts of things. So, so what they've dressed up, one of their claims now, is that this is just deceptive advertising, that it's like the cigarette cases where the tobacco companies refused to admit that their products were going to kill you. And for years and years, the petroleum companies refused to admit that they were, causing potholes in Boulder, and an equally horrible result from their products, and so they engaged in deception. Right? I don't know whether this meant they could have also sued them in the 1970s on the theory that their products were causing global cooling, or whether if they had said at that point that would now be a claim to say that it didn't cause global cooling, it actually caused global warming. But basically they've got this slick theory that says we don't need to worry about these trade-offs. We don't need to worry about the impact of people of Boulder because it's just false advertising. And if people had known this, they wouldn't have bought as much gas for their cars.
But even under that theory, Todd, I mean, if you and I probably both agree that the ability of Boulder to show that a meaningful proportion of the fossil fuels sold in Colorado would have been changed had Exxon said something different about climate change in 1987 or whatever. I mean, I think you and I are both incredibly skeptical they can show that.
Right.
But the fact that, in no other area do we say, just because a plaintiff has a theory that once we actually think seriously about it seems crazy, therefore the Supreme Court is supposed to come in and dismiss it, right? There's no history of that. Rather, if we expect courts to play their role of filtering these sorts of things, and if they fail to, we expect legislatures to fix it. I just don't understand why in this one case, folks, and I should just note, Professor Zwicky was my professor in law school, but why
Todd,
in this one
how
area—
have you miseducated
Yeah,
this
I know.
person so badly?
why
Come
in
on,
this one area—
correct your student.
folks who usually are like, courts do law, legislatures legislate, are so willing to throw that out the window just because we have a Congress that is more interested in being on TV than it is in legislating.
I can't think of any situation like this. I mean, I can't think of any situation in American history where you had—
The gun suits. The gun suits are a good example, right? I mean, the gun suits example is that you, when you sell a gun, you have to be able to, you're going to be held liable for the fact that some percentage of your customers are going to do bad things. And under traditional tort law principles, all these suits were nuts. And yet some plaintiff lawyers looked like they were going to get lucky. Some courts refused, allowed to hear these cases. And so what happened? Congress said, look, this is an organized campaign that's not about, in our judgment, about getting redress to actual victims. This is rather a campaign to subvert the Second Amendment and the right of people to own guns. And so we, Congress, are going to do something about it because when courts get out of their lane, that is what we, the legislature, are supposed to do. So we have seen this.
Right. No, I disagree. I don't think Americans suing Americans for selling guns in America is at all like trying to affect the entire global economy.
But that's not what the suits. That's not what the suits
potentially,
are.
that's what the effects of
Let
these
the old
suits
man
are.
finish.
Yeah, that's what the effects of these suits are. These are, maybe that's stretching it, but we're talking about rearranging the entire global economy through litigation. I think that's definitely different from a pigsty in a residential neighborhood. And I think that's different from even the gun cases. Maybe gun cases stretch the point, and we're talking about questions of foreign affairs that Michael had, and I think we had a sensible understanding. If the understanding this is generally a federal question to deal with these sorts of things, that's a sensible way of dealing with this. That just strikes me as kind of is different in kind from most any other question that I can think about, with implications and the ability to bring these repetitive nuisance suits over and over in all these different jurisdictions. That just strikes me as something different. So.
Yeah, and Jonathan, just to respond to your point about when have we done this before, going back to the beginning of the Republic, we've had a debate about what law applies. And we had federal common law, there was the Erie decision. After the Erie decision, obviously we have specialized federal common law. Justice Ginsburg talks about the keener understanding of specialized common law, and she puts environmental law clearly under there. So the question isn't, why don't they get to try the case? It's under what law? And they've chosen the wrong law. The right law is federal common. The keener understanding of federal common law puts these issues under federal law and then under the Clean Air Act.
So Justice Ginsburg says the opposite.
History
she says at the end of her opinion, whether these cases, she says these cases were, AP was originally both filed under both federal common law and state law. The Second Circuit only decides the federal common law claim after sitting on the case for 2 years. Justice Sotomayor was never asked about that at her confirmation hearing, even though she was on the panel, but that's another issue. The Second Circuit decides the federal common law claim. That's what goes to the court. She says at the end of her opinion, whether the state law cases can proceed is a function of whether they were preempted by the Clean Air Act. And we know, given that the Clean Air Act's savings clause is even broader than the Clean Water Act's savings clause, that the state law claims, including for transboundary pollution, are therefore preserved. How do we know that? Because the Supreme Court said so in Ouellette, and we know, in fact, what happened after Ouellette in terms of the litigation proceeding.
But I'm just going to quote this. She says, sought relief under state law, in particular, the law of each state where the defendants operate power plants, which is to say, she opens up a possibility to debate whether a state could bring a case under the law where the emissions happen,
That's not how that works. So the International Paper versus Ouellette is actually a good example of this, right? So the case is brought, and it's going up to the Supreme Court effectively on the choice of law issue. The Supreme Court says, okay, Vermont, you're going to have to sue this New York facility under New York law, and it now goes back to the court. It's the same case. It doesn't ever get dismissed. It doesn't get refiled. It's the exact same case, and now the lower court is just told, okay, when it gets to the question of which law to apply, which often comes up in the course of litigation, we're telling you what the answer is. So the same thing in these cases. Instead of trying to get them dismissed, the defendants could be saying, we want a ruling of, as a matter of law, what law is going to apply in what context, force a state court to say, if you want to reach emissions that occurred outside of Colorado, in the Boulder case, for example, you're going to have to look at the law of every state for the proportion of emissions you want to claim credit for. Get the lower court to rule on that, or they just exclude those emissions from the case. The point is that in the way litigation is done, fine. Then the damages that they're asking for aren't Todd's nightmare scenario, but are actually only a tiny bit. The point is that we handle these things in litigation.
I'll add one last sentence. There was no federal common law of guns.
Okay, we're over time. I was worried this panel would not be as exciting as the first panel. And so maybe for those of you who make it to the end, we'll have a massive panel where all the panels can argue with each other, which would be a lot of fun. I just want to make one last point, just stepping back. The lesson I draw here is either, regardless whether Jonathan's right or Todd and Mike are right, both of you are arguing for judges to make the policy in the end, because the Congress is not going to pass a law. And so it's really going to be, is it going to be state judges or is it going to be federal judges who make policy? And there's reasons to question whether either of them should, right? I think state judges, I'm a Berkeley person, we don't like state courts at all, and we sort of generally teach we want the federal government to run everything, and we worry about the politicization of state judicial elections and so on. And but we also, right, this Supreme Court is really against judges making policy too, right? That's one of the lessons of the Roberts Court. But I just leave you, inevitably it sounds like it's going to be judges, whoever wins will make the policy on this question. And I want you all to ask yourselves, is that really the best policy-making outcome, to have state or federal judges make these decisions? So join me in thanking panelists, and we'll take a 15-minute break.